Hi there. So let's continue with the elements of a valid contract. So in the previous video we considered offer and acceptance. Then the next one or the third one is called legality. Legality simply means that the subject matter of the contract has to be legal for the contract to be valid or enforceable in the court. What does that mean? The subject matter simply means the terms of the contract should be legal. Remember my illustration? If I say I'll give you $10,000 for you to go and kill somebody, meaning the subject matter of the contract is illegal. So once the subject matter of the contract is illegal, the contract is not valid, the contract cannot be enforced in the court. If you should take me to court for the non-payment of the $10,000, the issue is illegal. They will talk about the crime aspect of it, and the two of us are going to be, or the criminal aspect of it, and the two of us are going to face the state in a legal suit. So that is what we mean by legality. The subject matter of the contract, or the terms of the contract, the terms of the agreement has to be legal. If it is legal, then it will be enforced in the law court. That is very important for you to understand. So whatever offer I am making, before you accept the offer, you must make sure that this offer is legal. The next thing is capacity. Capacity has to simply do with the ability of an individual or a party or an entity to enter into a contract. That is what we mean by capacity. Now, so when it comes to individuals, usually the individual is supposed to enter or can enter into a valid contract if he or she is above what? 18 years. Okay, other countries is 16, other places is even 15, but there are some contracts, even if you are 16 years, you can enter into it. So for individuals is the age limit. So let's take the base. It should be greater than or equal to what? 18 years before you can enter into a valid contract. But for companies, for an organization to enter into a valid contract, the capacity simply means the organization has to be what? Registered. It has to be a legal entity for it to enter into a valid contract. Now, even though we say that individuals cannot enter into a valid contract below 18, there are what we call exceptions to this rule. So there are exceptions to the law of capacity, which means that minor, so we have what we call minor and major. Minor are the people below the 18 years or below the bar, then the major are all above it. So a minor cannot enter into a valid contract, but there is an exception to that. The exception here is that a minor can enter into contract of necessity. What does that mean? If, for instance, a child is 12 years old and is hungry and walks to a restaurant and say that, I am hungry, give me food to eat and I'll pay you later, or I'll let my parents come and pay you later, or I will pay you later. It will be a valid contract if the restaurant sells the food to the boy and the boy will be obliged to pay. Why? Because at that point, at that station of life of the boy, it was necessary, or it is necessary for the boy to what? Have some food to eat. So that is the exception. They can enter into contracts of necessity. Another example is that a minor can enter into contract of apprenticeship or training. So for instance, if a minor goes to a seamstress or goes to a carpenter or goes to any service and say that, oh, I want to learn, so I'm not doing anything, I'm jobless, I'm homeless, I'm an orphan, so I want to learn, but I don't have money to pay you now, but you just continue to train me, continue to teach me, and I will pay you the money later on. If they enter into that contract, that becomes what? A valid contract. So these are some of the exceptions that we can talk about in relation to capacity to contract. So what are we saying? There has to be an offer. That offer has to be accepted. The agreement that is made has to be legal, and everybody must qualify under the law to enter into the contract. So capacity to contract is literally about what? The qualification. Are you qualified to enter into the contract you are entering into? If you are not, then it becomes illegal. But if you are, it becomes legal and binding before the court. Now, if you are not, it may not be illegal, but it will be a void contract. It will not be seen or considered by the court. Then we come to the fifth thing called intention to create legal relations. Now, this is very one of the funniest one. What it simply means is that whilst we are agreeing, the parties to the contract must have it in their mind, or must have it consciously, that the breach of the contract will result into an action in court. That is what we mean by intention to create legal relation. Meaning, whilst entering into the contract, the parties to the contract must know that the breach of the contract will result into an action in the court. So if whilst you were enrolling in this course, you saw the terms and condition page. Now, there was a box there that you were supposed to take. Prior to taking the box, you were told to read the terms and conditions. Now, if you did not read the terms and conditions and you go and do something that is outside our terms and conditions of operation of this particular service, then we will take you to court. Now, when you take you to court, ignorance is not an excuse. You cannot say, whilst I was buying the course, I did not know that this is the terms and conditions. No, that was why the box was there and you were supposed to read before you take it. That's what we mean by intention to create legal relations. So anytime you are entering into contracts, you need to understand that if this thing does not go well, there will be an action against me. If the person does not do what he or she is supposed to do under the contract, I can take the person to court, and it is what? Going to be valid. So that is what we mean by intention to create legal relation. Then the sixth one, which is the most important thing, which is one of the most important, is also consideration. What is consideration? Consideration is simply the price you paid for the contract, or consideration is simply the sacrifice made by one party in return for the benefit received from the other party. So what then is consideration? I tell you, I am selling my laptop for $5,000. You agreed to buy. It is legal transaction. You are matured, I am matured, we can enter into such contracts like that. Or you are a major, I'm a major, we can enter into such contracts. The laptop I am giving to you is my consideration, and the money, $3,000 you are giving to me, is your consideration. So the consideration is what is lost, or the sacrifice that is made in return for the benefit that is received from the other party. But when it comes to consideration, there are what we call types of consideration. And basically there are two types of consideration. We have what we call executed consideration, and then we have what we call executory consideration. An executed consideration is a consideration that is undertaken, or which takes place what? Immediately or in present time. What does that mean? If I have my shop, or if I'm selling the laptop, then you bring me the 3,000, I give you the laptop, then it becomes what? Executed consideration, meaning that the transfer of the consideration takes place simultaneously as the contract is signed. So that is what we mean by executed consideration. So when you go to the provision shop and you go and buy sardine for $5, when you give the money to the shop attendant and she gives you the sardine, then that is called what? Executed consideration, because she is losing sardine now as you are undertaking that contract, and you are also losing $5. That is what we mean by executed contract. Then the second one is executory contract. Now this is where consideration is passed or is transferred sometime in the future, meaning that with the executory contract, the consideration is transferred either by both parties or by one party sometimes in the future. So if you come to me and say that I should teach you for the ICAG exam, so for instance, like this course that you have enrolled on, it is an executory consideration. Why? Because you are either making monthly payments, and courses are also dripped, so you are going to be having access to the courses as and when you go on with what the study. So it is an executory consideration. But if it was a one-time thing, then you say that, okay, Nhyira, I want to have a one-day session with you, private class. Then you come and I said, okay, for the one day I'll charge you 500 Ghana cedis for 3 hours of my time. All right, so you pay me the 500 Ghana cedis, I teach you for the 3 hours, boom. That is called executed consideration. All right, meaning we have undertaken the transaction immediately. Or a company goes to buy a vehicle from Kantanka Automobile. So when we buy the vehicle from Kantanka Automobile and we pay them, maybe we buy one of their SUVs or whatever it is, maybe for 87,000 Ghana cedis. We buy that vehicle, boom, what do? We pay them the money. They are losing their car, we are giving them $75,000. It is called executed consideration. But if we buy the car on credit, they have lost the car, but we are going to be making the payment in the future. So that time, that will be referred to as what? Executory consideration. So these are the two types of consideration that you need to understand. The next thing you need to understand are what we refer to as rules of consideration. Rules of consideration, or what we call principles of consideration. The first one is that consideration has to be valid. Right? So it goes back to what we've been mentioning or talking about. Valid. Okay? Has to be valid, or what we call legal. Okay? Consideration has to be a legal consideration, not valid, rather should be legal. Consideration should be legal. So anything I am doing under the contract or anything you are doing under the contract should be what? Legal. So if a company employs me that I should do shady accounting for them so that they pay less tax, meaning what I am doing is illegal, right? Because if I am going to, now remember, companies pay a lot of money to tax consultants to prepare their books in such a way that they pay minimal tax. Because remember, tax evasion is illegal, but tax avoidance is legal. Tax evasion is where you are supposed to pay tax, but you don't pay. Tax avoidance is where you use the tax laws into your advantage, present your statement in such a way that you pay low tax. But then after that, if the government, or yes, the tax authority audits your account and they find out that you had done some shady deals in the accounts, then that becomes illegal, and so you'll be penalized. So if a company employs me that I should do their tax for them and they are emphatically saying I should present things in a shady manner, the money they are giving me is good, but the act that I'm undertaking is illegal. So the actions, the sacrifice that each party is making under the contract has to be legal. That is the first consideration. The second consideration is that the consideration must be possible. Okay, performance should be possible, or performance must be possible. In other words, if we agree on something that I cannot do, then it shouldn't be a valid contract. So it shouldn't be something outside the box. It should be legal, but also it should be something that is what? Possible to be undertaken. The next thing is that consideration must pass from the past. In other words, it means consideration must not be in the past. All right? Consideration must not be in the past. What does that mean? If, for instance, I give you money 2 weeks ago, I gave you $10 2 weeks ago. I just gave it to you 2 weeks ago. Then I come to you today, right now, that wash my clothing for me, wash one of my wooden clothing for me because I gave you $10 ago. No, it's not legal. It's not a valid contract. So I cannot rely on past performance to tell you to do something for me today under contract. Okay, so that is what we mean by consideration must not be in the past. Now, consideration must be sufficient but not necessarily adequate. consideration must be sufficient but not necessarily adequate. Another way we can put that is that consideration must not be equal but must have some value. What does that mean? When I'm giving you my laptop and you are giving me $5,000, we cannot say we cannot say it's the laptop worth $5,000 or is the $5,000 worth the laptop. We cannot say that, but at least they have what? Some value. So the consideration should not be sufficient. Like they shouldn't be head to head. Like I'm giving this, so you do also have to give this. I'm doing this, so you also have to do that. It shouldn't be. It's not. We can't really make it sufficient, but it should what? Have some value. So that is what you have to understand about that rule. Now, but then when it comes to consideration also, there are some exceptions that we need to consider, especially about the fact that consideration should not be in the past. Remember my illustration with you in relation to when I said that you buy a car from Kantanka and you make payments in the future. That is executory consideration. So meaning that you'll be making a payment, you are making a payment today because of something you did in the past. So there are exceptions. So we want to look at 3 instances that past consideration for a promise is sufficient to make the promise binding. The first one is that past consideration is sufficient to create liability on bill of exchange, such as check. Most checks are used to pay existing debts. So that is what we mean by the instance where a past consideration is sufficient or a binding consideration. So once I'm giving a bill of exchange, a check, then it means that I owe you some debt. And remember what we talk about under liability. We said that liability is what? A present obligation in accounting. A present obligation as a result of what? Past events. So I am giving you a check today because I owe you or I bought something from you. So even though the event is in the past, it qualifies to be a consideration. Next one. After 6 or some cases 12 years, the right to sue for the recovery of a debt becomes statute-barred. If after that period, the debtor makes written acknowledgement of the creditor's claim, the claim is again enforceable at law. What does that mean? So there are some kinds of debts, and in some cases it could be 6 years or it could be 9 years. So it's like what we say that equity delay is equity denied. So what we say here is that if, for instance, somebody has a right to recover some amount of money from somebody, so like you owe me, and I'm at every right to have taken you to court, all right, to take the money, but after 12 years or after 6 years, depending on whatever legal act we are applying in whatever specific case, I don't take the action. If later on you come and acknowledge that, oh, you owe me, then the case can now be taken to court and it can be resufficed. The third thing is, when a request is made for a service, this request may imply a promise to pay for it. If after the service has been rendered, the person who made the request promises a specific reward, this is treated as fixing the amount to be paid. So that is what I was saying. So you come to me and you say that, Nhyira, you want me to teach you. Because of that, I will be charging you $1,000, right? For teaching you, I'll charge you that $1,000. For teaching you for maybe once a week for 3 months or 4 months, something like that. That becomes an executory consideration, because I am teaching you, or you have paid me, but I'm teaching you in the future. Or you say that after teaching you, you will pay me. Okay, so I have finished the teaching, you are supposed to do the payment. So that becomes also a consideration in relation to that. So that is what you need to understand when we talk about the issue about consideration. So one, remember, offer, okay, a promise that is made to be bound on certain term when terms when accepted. An acceptance is an unconditional consent on an offer that is what made. Legality, the subject matter, the terms of the agreement should be legal, all right, should be enforceable, should be seen as right before the law. Capacity, the ability of an individual, an entity to enter into a valid contract. And remember the issues we spoke about under the exception. Then intention to create legal relationship, and which is always implicit in a contract. And because when you are actually doing a contract, they won't tell you that um, if you don't do it, we'll take it to court. So it's not explicit, it's implicit. Are you getting it? The offer is explicit, acceptance is explicit, legality is implicit, capacity is almost or sometimes implicit, intention to create legal relation totally implicit. So you are signing the contract, you should know that the contract you are signing, if you breach it, we will take you to court. That is what we mean by intention to create legal relation. And then the last one is the issue about consideration. How much we are losing, how much we will not get, how much we are sacrificing or giving up in return for the benefit that we are receiving from the other party. So these are what you need to understand about the elements of a valid contract. So I will see you in the next video as we continue with what we refer to as vitiating factors, and also consider the issues about termination of contract, and also the issue about remedies available to an injured party in a contract. So I'll see you in the next video as we talk about that.